Well, welcome everybody to our second webinar this summer of our summer road trip series focused on intellectual property. My name is Matt O'Brien. I'm a program manager with the Tech Engagement Office. Joining us on our call today, we also have Anna Kudala, who's our IP lead, and David Narciso, who's a patent attorney for the Air Force Research Laboratory. Same as we did last week, our main speaker today will be Dr. Gary DeBoer, who is a professor from LeTourneau University and a patent agent. He's joining us over the summer, virtually of course, through the AFRL Summer Faculty Fellowship Program. And today he's going to be talking about what is patentable. So go ahead and take it away, Gary.
All right, thank you, Matthew. Last time we were together, we talked about what is a patent. And we saw that a patent is a right to exclude others from making, using, offering for sale, or selling the invention throughout the United States. And a similar thing if your patent is a process. So a patent is a right to exclude others from using the thing that you claim to have invented. And then we talked about why we might want to patent something. And we talked about the fact that property that requires investment needs protection, such as real estate property, your home, for example. We said that if you don't patent the invention, then patents on improvements can be practiced by others with no restrictions on the stuff that you invented. We said if you don't patent, the taxpayers may pay twice with respect to the Air Force procuring inventions for use. We said that patents allow transfer of technology for purposes of accelerating the development of new technology in that technology transfer life cycle. And what's important to inventors is that a % of revenue goes back to the inventor, and that patenting can create economic value by adding intellectual property to the economy. So that's what we talked about last time. Today we want to look forward and plan our next stop. And our next stop is to talk about what is patentable with respect to ideas. And then next week, we'll talk about the application process. And then our last webinar, we'll talk about how you can engage with the Tech Engagement Office. So we're going to begin by talking about what is patentable. And people tell me that the craziest things are patented and they just don't understand. For example, this toy, this bone toy, was patented for people to use to play with their dogs. I said, well, how can you patent a toy for a dog? That's been out forever. But you'll notice that this is a design patent, as you'll see in the D in the patent number there. So this particular patent is for the design of the toy. It doesn't really patent toys to be used with dogs. So you gotta be a little bit careful there. And then somebody said, well, how about this one? This is a light changer patent. And, you know, it's like that joke. How many inventions does it take to change a light bulb? Here you have a patent for changing a light bulb. Actually, I think this one's pretty cool, you know. And if you could, have something like this is pretty neat. And you wouldn't have to change light bulbs anymore. I kind of like that one. I don't see what's so funny about that at all. And then there's this one here that everybody says is the craziest patent ever. It's a patent that allows a mother to birth a child by spinning her on this table so that the centrifugal force brings the child out of the mother. And yeah, it sounds kind of crazy, doesn't it? So anyway, people tell me there should be laws about these patents, about what you can patent. And they're exactly right. There are laws about what can be patented. And if we look at the United States codes here under Title 35, the first section there we see is the law that establishes the USPTO as a governing body with respect to patents. And if you're interested in intellectual property at all and patents, I would suggest you go to the uspto.gov site and learn more about patents. Today, we're going to talk about 3 specific laws with respect to the patentability of your idea. And so the first one is USC 101, which will talk about what the subject matter is. We'll talk about USC 102, which talks about novelty. Is this a new thing? And then the last law we'll talk about is USC 103 with respect to the obviousness of your idea. All these are in Title 35 of the United States Codes. So let's begin by looking at USC 101. This is what it says. Whoever invents or discovers any new and useful process such as the Haber process, machine, so something like a sewing machine, manufacture, so something that is manufactured like a chair, or composition of matter, and this is something that chemists like to patent, or any new and useful improvement thereof may obtain a patent. So with that idea, here are some things that we could ask, which of the following might be patentable? Could you patent a mathematical formula used to find prime numbers? Well, you may say that, well, that seems like a process and it's useful because you find prime numbers. Maybe. Or you could ask about old shoe polish for fish bait. And you say, old, that doesn't sound good. We want new, but if the fish bait is new, maybe we could. How about the human brain? Maybe you've heard some news stories about the patenting of the human brain. If you were the first to discover that humans had a brain, could you, under this law, patent the human brain? It says discoveries that are useful. Is the human brain useful? Possibly. Letter D, a newly discovered element. Could you patent that? How about a process of using shoe polish to make fish bait? Well, that sounds really good because it's got process in there. Anyway, the point is here, some of these are not easy to determine if you can patent them or not. Can you patent the human brain? According to the text of the law here, it almost looks like you could if you discovered the human brain. Well, the Supreme Court has weighed in on these things a little bit, and they said, yeah, the text says this, but legislators meant this by that. And so the court has decided that the legislators meant that you should not patent these things. You should not be able to patent abstract ideas, laws of nature, natural phenomena, or products of nature. So if we look again at our options here, a mathematical formula here would be an abstract idea. So you could not patent it, even if it sounds like a cool thing to do. Old shoe polish, doesn't matter if you're using it for fish bait or anything else, you're still trying to patent the shoe polish, and if it's old, you're out of luck. The human brain. Even if you discovered the human brain for the first time, it's still a product of nature, and you can't patent it. Likewise, with a newly discovered element, again, a product of nature. So those guys are also out. So we're left here with E, a process of using shoe polish to make fish bait. And I think that that could still be patentable if it's a new process. So here's a question for you, survey question number 1. And we can read this for you. Would a genetically engineered microorganism for use in cleaning oil spills be patentable under 35 USC 101? And Noah, if you could add that poll survey in there so that people can answer yes or no. So the law says whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof. So if you think that this should be patented or patentable, say yes. If not, say no. How are we doing, Noah?
We got 3 votes in so far. Looks like a couple more people are just trying to get their votes in. If you are Andy, remember you can vote in this poll, and I would encourage you to.
Okay, we'll give you a few more seconds here. 5, 4, 3, 2, 1. So what are our results here, Noah?
Okay, so I just ended the poll, and we ended up getting a landslide victory here for yes, with everybody going for yes.
Yeah, and this is because most of us have already known these things have been patented, but it wasn't so clear when this first came up to whether it should be patented or not. The patent office said no. They said no, you can't patent living things because the law 35 USC 101 is not intended to cover living things. There is special laws with respect to plant patents, and those should cover those living things. And so way back in 1972, the answer to this question was no. Now, most of you said yes because you know these things are patented. So what happened? Well, there was another court of appeals that said, yes, these things should be patented because it's not a question of whether the thing is living or not, but whether it's a product of nature or a human-made invention. So that was 5 years later after initially the patent board said no to this patent. And then later in 1980, the Supreme Court also affirmed the Court of Appeals here and said yes as well. And so now most of us know that, yeah, microorganisms that are genetically engineered can be patented, but it wasn't always the case that that was true, but it is now. All right, so most of you guys are in the know here. Here's another one. This is from a patent by Morse for a telegraph type thing, okay? And here's claim 8. And claim 8 reads like this: I do not propose to limit myself to the specific machinery or parts of machinery described in the foregoing specification and claims. The essence of my invention being the use of the motive power of the electric or galvanic current, which I call electromagnetism. However developed for marking or printing ineligible characters, signs, or letters at any distances, being a new application of the power of which I claim to be the first inventor or discoverer. So Noah, if you can raise this survey question and ask our audience, do they think that this claim is a patentable claim or not patentable claim?
Yep, the voting has started now.
So again, USC 101 says that things that are a process, a machine, composition of matter, a manufactured item, those can be patented. All right, I'll give you a few more seconds here. 5, 4, 3, 2, 1. All right, what's the answers here, Mr. Noah?
Seems like we got a bit of a streak going here. We got everybody going for yes again.
Well, the answer in this case was yes by the patent office in 1840, and they issued this patent to Morse for his telegraph machine, and this specific claim as well was approved. But later, in 1854, the Supreme Court said no. They said, no, Morse, you can't patent the idea of electromagnetism. That's a natural phenomenon. And that's what you're trying to do in Claim 8, patent everything that is electromagnetism. And so Claim 8 eventually became unpatentable. So anyway, these are interesting stories from history with respect to what things are patentable and what aren't. So let's talk next about novelty here. Novelty means it's new, that somebody else hasn't already invented this thing. And this is how the code reads. USC 102. It says a person shall be entitled to a patent unless the claimed invention was patented, described in a the tongue twister there, a printed publication or in public use, on sale or otherwise available to the public. We say that these are disclosures. Paragraph A1 there. These are disclosures of the inventor. So if the inventor has been selling this thing or talked about it, he can no longer patent it unless he files before he does these disclosures. The second paragraph here, A2, is similar, and it talks about disclosures, but they're disclosures by another. So somebody other than the inventor has used this thing in public or filed for a patent on it already. So these two are disclosures. And we say that disclosures are a bar to you getting a patent. You are barred from getting a patent if you have disclosed or somebody else has disclosed the invention to the public before you file the patent application. Okay, so with that idea, and USC 102A, paragraph 1 and 2 here are some possible scenarios. Okay, and the question is, under which of these scenarios can the engineer still get a patent? So take a minute here. If Noah can raise survey question number 3. And if you guys can read through these different scenarios and answer whether you think that the engineer can patent these or not, there you go. So you can select more than one here. The first one, engineer invents a new welding machine and the whole base uses it for a month. Second scenario B, engineer invents a new chemical process and presents it at American Chemical Society conference last month. Scenario C, the engineer invents a new prosthetic and publishes it 2 years ago in the Journal of the American Medical Society. And D, the engineer invents a new welding machine and keeps it secret. The Naval Research Lab engineer independently comes up with the same idea and files a patent application for the same invention. So which of these do you think the Air Force engineer can still apply for a patent upon? Enter your answers now, if any of them. Okay. We'll give you a little bit more time here. 5, 4, 3, 2, 1. Okay, what's our answers, Noah?
Okay, so we got a little bit of more division on this question here. We got the first 3, A, B, and C, were all tied, but D did come ahead in the end with 67% of the votes.
Okay. All right, well, let's look at each one of these. The engineer invents a new welding machine and the whole base uses it for a month. So the question here is the use here. Is this a public use? If it's a public use, then you would be barred from getting a patent under USC 102, paragraph A, subparagraph 1. If the base is not a public use but a private use, you might still be able to get by and get a patent. Let's look at letter B. The engineer invents a new chemical process and presents it at a conference last month. Well, a presentation at a conference would be just like making it available to the public. And if the engineer does that before he files the patent, he would be barred from getting a patent. So B for sure is out. A is maybe, depending on whether that is a public use or a private use. Letter C, the engineer invents a new prosthetic here and publishes it 2 years ago. Okay, so again, he's making this a known to the public by this publication, so that would bar him from being able to get a patent. And letter D, the engineer invents this new welding machine, but somebody else also invents it and they file before the AFRL engineer. So this comes to subparagraph 2, where another has already filed before the effective filing date of the AFRL engineer. So the AFRL engineer would be out there as well. So the only hope we have is for scenario A, that this guy here could get a patent claiming that the use on the base was a private use and not a public use. All right. But things get a little bit more complicated because there's a paragraph B in USC 102A, or USC 102, there's a paragraph B. And paragraph B has what we call exceptions to paragraph 1A. And the exceptions are that if the disclosures made in A1 by the inventor are made within 1 year of filing for that patent, then those disclosures won't count against the engineer. So now, with that better knowledge here, I think we have polling question number 4, don't we, Mr. Noah? The same questions, but answer them over here again, asking yourself whether our engineer in these various scenarios can still get a patent. Noah, can you raise polling question number 4? There it is. So can the engineer who had his machine used on base for a month still get a patent? How about the engineer who presented at a conference last month? Or the engineer who published 2 years ago in the Journal of the American Medical Association? Or that engineer who had his machine patented by somebody else? What's our results, Mr. Noah?
Okay, so ending the poll, we have another tie. We have a tie between A and B.
Okay, so I think our audience is correct. In letter A, our inventor can get a patent because it was only a month ago, so they're within that 1 year grace period. In letter B, the conference was just last month, so again, our inventor is within 1 year of the grace period to apply for a patent. In letter C, this was 2 years ago, so that is outside the grace period because it's more than a year. And in letter D, it doesn't matter the time here. The bar here is for paragraph A2 because somebody else filed for this before the inventor, so it doesn't really matter when the disclosure is made by our inventor. So our audience is right. A and B would be patentable by these engineers. So good. Smart audience we have there today. So the point of this little exercise here is to say that after the inventor publicly discloses, the inventor has only 1 year of grace in which to file for a patent. So if you talked about your invention at a conference last month, you better start working on getting that patent filed. And if you did present it last month, don't be afraid that you can't patent it. You still can, but your clock is now ticking. Another thing that sometimes confuses people is that the laws have changed recently with the passing of the American Invents Act. This was a big reform to patent laws, and it passed by a vote of 89-9 in the Senate. So how often do you see a vote like that? And it was sponsored by a Democratic senator, Patrick Leahy, and a Republican representative, Lamar Smith. So a very bipartisan sort of approach to patent reform. And it changed a lot of things. In the past, things were much more local, and things outside the country wouldn't count against you for disclosures, but now they do. But the biggest change that most people will probably realize is that now the US is the first inventor to file. In the past, the US was the first inventor to invent. And you could debate about who invented first. It didn't matter who filed first. But now the question is only which inventor filed the application first. So patent laws have changed in the last few years. So if you knew things from the past, you might check into what the laws are today with these things. Getting back to our little flow of our laws here, let's now look at our third law, USC 103, with respect to obviousness. Okay. It says, a patent for a claimed invention may not be obtained, even if the claimed invention was okay under USC 102. And it goes on to say, if the difference between the invention and the prior art is such that it would be obvious to somebody who's skilled in the art to do, then you cannot get an invention. So the obvious question here is, what does it mean to be obvious to the patent examiner? Well, the courts have come in and they have sort of helped to clarify this a little bit. And the big case here was Graham versus John Deere. And the courts have said there should be this sort of stepwise process here to determine this obviousness. And they said the first step is to look at what is being claimed, what is the scope of the invention, and what is already out there in the public domain, what is the prior art. And the second step is to ask what's the difference between this new invention that's being claimed and the old stuff that's already out there. And then the third step is, what would somebody of the ordinary skill in the art be able to do with the old stuff? Could they obviously connect the old stuff together to make the new stuff, or does it take some inventive step to connect the old stuff to make the new stuff? And then finally, is there any objective evidence to show that this would be non-obvious? So here are some rationales that examiners use to say that your invention is obvious. They might say you're just combining parts that are already out there to do what people would expect them to do. You just bolted another piece onto the chassis of your machine. There's nothing new there. Or maybe they would say that I just substituted one part for another part. Everybody knew that that would work, no big deal. Or they say, well, you used a known technique from one discipline and applied it to another discipline. That's an obvious thing to do. And they might say it's obvious to try these things. You know, if you're building a chemical compound and you need a halogen or some group on there, you might try all the halogens. There's only so many of them, so it's obvious to try all of them. So they might, in general, talk about teachings, suggestions, and motivations that are available in the prior art that would point somebody to do what you did. And if any of that is out there, the examiner is going to use it against you to say that what you did was obvious. Now, you're going to have to come up with some evidence to the contrary here. You're going to need some evidence of non-obviousness. You're going to have to claim that what you put together, that somebody of ordinary skill in the art couldn't do this, that there's some critical factor here that had to be just right, or in a certain combination to make it work, that it was not easy to do. You might say that you put A and B together and it didn't give you C like people thought, but it gave you something else. And though, yeah, I put together two prior art things, but I got something new that was unexpected. Or you may claim that your commercial success proves that your invention was a non-obvious one, otherwise other people would have done it before you. Likewise with a long-felt need. People have been trying to cure cancer forever. If there was an obvious answer to the cure for cancer, somebody would have come up with it a long time ago. Yes, and that plays into failures of others or skepticism of experts, and there's other possible arguments that you could make here that might show evidence that what you did was not obvious. This is always a tough argument to make. All right, so we've talked about these three laws: the patentability of subject matter, the novelty, and the non-obviousness. You might put this together and take a little flow diagram of questions that go something like this. For USC 101, you might ask, is it a useful process, machine, manufacture, or composition of matter? And if the answer is yes, then you would go on to USC 102 and ask yourself, is it a new thing? You would say, has it been patented, published, used in public, or on sale any place in the world? And if the answer to that is no, then it's still a new thing. And you'd go on to ask the question of obviousness. Is this an obvious thing? And if the answer is again no, well, then you might have a pretty good idea here. Now, you say to me, Gary, how am I going to be able to answer all these questions? I don't know. Well, you don't have to have the answers to all these questions because you have Anna. Anna is there to help you find the answers to these questions. So if you have even an idea that you think might be patentable, contact Anna and she can help you answer these questions. And you don't really know until you apply for the patent application and see what happens. But, you know, work with Anna and she can help you with a lot of these sorts of things. But keep these questions in mind as you do your work in the lab. So what have we talked about on our trip here, our virtual road trip across New Mexico and up into Colorado? We talked about what a patent is, a right to exclude, why you'd want to get a patent, and today we talked about what is patentable ideas. Next time we're together, we're going to talk about the application process and engaging with the Tech Engagement Office. So the subjects, what we'll talk about next time will include things like types of a patent applications, filing dates and the life of a patent, the timeline of the examination process when the patent is pending, and the flow of the examination process. And we'll also look at the parts of a patent application and compare those parts to the research paper that you might write for publication. So with that, I'll give it back to Matthew. If you want to go over some questions or comments, it's all yours, Matthew.
Thanks, Gary. So we can open it up to our attendees. If you type into your Q&A box, Noah will help us field those in real time, and we can try to answer all of your questions.
So we did have one question roll in under the chat. I'm guessing he meant to put it under Q&A, but he accidentally put it under chat. And it went in around the time that we were going over question number 3, over the 35 USC 102 paragraph A. And the question was, can't you still patent if presented, if done within a year?
Yes,
And
you
that
can
was from
still
Mike.
patent if you do it within a year. And maybe this was before we got to paragraph B. So paragraph B is an exception to paragraph A. Paragraph A says you can't patent if you've disclosed it all. In paragraph B, it says, well, we'll cut you some slack, and if you've disclosed within the last year, we'll still let you file for the patent application. So the questioner is correct that they can still patent if you've disclosed within the last year, but that's only correct because of paragraph B. Paragraph A would have knocked you out. So in general, it's better not to push your luck. Yes, and it's better to patent first before you disclose anything. And this is why on your invention disclosure form, they'll always ask you, have you made any disclosures? When was the date of your disclosure? Because the date of your disclosure is anytime near a year ago, the people in the patent office are going to have to get working quickly to file your application before that year of grace expires.
Okay, so we have a couple more questions coming in. One's asked, we have Aaron Lane, sorry if I mispronounced your name. He was wondering if you can go over why an algorithm is not patentable.
An algorithm is an abstract idea. It's just a concept in your mind. Okay? Now, you may say, well, I know of some algorithms that were patented. If that's the case, they had to be incorporated somehow into some hardware type component. There had to be some physical machine or something that was part of the invention, because the algorithm itself, that abstract idea, is not patentable by itself. If it was connected to something that did something, then maybe it could be part of the invention. But an abstract idea, a mathematical formula, physical phenomena, none of those things can be patented.
Okay, so we have another question here coming in from Mike again, who had the question earlier about presenting patents. So his question is, so does unclassified limited distribution use of an idea constitute public disclosure?
Oh, well, it depends what you mean by unclassified use of an idea. Can you read that again?
So that's an Air Force term,
Oh, is that
right?
Air Force terminology? Okay, Matthew, I'll let you take that
So
one then.
the way that we usually categorize outside the organization is if it's published in if it's published or if it's given at a conference. Usually, if it's shared with contractors that are working close to a program, we consider that an extension to the organization. So that's not necessarily a public disclosure, but each case would probably have to be looked at, depending on who you plan to share your invention with. And we can probably help give you a judgment on that.
Okay, thank you, Matthew. Yeah, you have to be careful about public use. Even if the public doesn't know that you're using something new in a public space, if you're using it in the public space, it still counts as a public use. So it's a tricky question. So I would certainly connect with Matthew and Anna if you have any question about what you should be disclosing to people that you work with outside of your organization.
So the follow-on question is talking about classified. So if it's classified, then no, that's not public. That's not a public disclosure. We actually have options for keeping an invention at that level as well. So you can actually file for a patent application, but you basically ask for a secrecy order to it so that it stays classified and that it's not published once the application's filed. So that is another option. But I guess each case, like I said, is a little bit different. So if you have a specific example, please reach out to me or Anna and we can help you out.
Yeah, those are good questions. Any other questions, Noah?
We do not have any other new questions rolling in right now.
Okay. Well, if you do have questions, if they come to your mind in the future, I would suggest to any of you to contact the Tech Engagement Office and talk to them about what your ideas are and what your questions might be. And they're a very helpful, open group, and I think that you'll be happy that you reached out to them. Also, if you want to email me your questions, you can email me at gary@afrlnewmexico.com, or you can email me to my Laterno email address, garydeboer@latu.edu. And I'm happy to answer your questions by email as well. Any other questions come in yet, Mr. Noah?
No, I think that might end up actually being the rest of the questions.
Okay. Well, it's too bad David Narciso couldn't get in. I think he sent a message saying that he tried and couldn't get in somehow. But hopefully he'll be with us in the next webinar and maybe be able to answer more of these questions as well.
Yeah, I just sent him an emergency invite a couple minutes ago, so he might be able to get in last second here.
Okay, it's right at the end, huh?
Yeah, hopefully. At least there's a chance.
Okay. Well, Matthew, do you have anything else to add here?
No, nothing else. We ask that if you enjoyed the presentation today, please join us again next Wednesday at 12 p.m. Mountain Time. And please tell your colleagues, tell your friends And we're happy to answer any questions during these.
And again, next time we come together, we'll talk about the application process, types of patent applications, the filing dates, and the life of a patent, timeline of the examination process, and the flow of that process, and the parts of a patent application.
Great. Thanks, Gary. And thanks, everybody, for joining today.
All right. Thank you.